Hello and welcome back to our channel everyone. Today we will discuss all the previous year questions of All India Bar Examination क्योंकि अगर आपको ये previous year questions आते होंगे तो फिर आप आराम से पास हो जाएंगे क्योंकि हर साल काफ़ी questions directly या indirectly repeat होते ही हैं, इसलिए ये questions तो आपको पता होने ही चाहिए। लेकिन MCQs बहुत हैं और उन्हें देखने में टाइम भी बहुत लगता है, इसलिए हम यहाँ उन्हीं MCQs को वन लाइनर फॉर्म में प्रस्तुत कर रहे हैं जिससे आपका समय भी बचे और याद करना भी आसान हो। इस सीरीज में हम एक एक करके सिलेबस के सभी सब्जेक्ट्स के वन लाइनर्स आपको प्रोवाइड कराएंगे और आज के वीडियो में हम आईपीसी के अब तक के ऑल इंडिया बार एग्जाम में आए हुए सभी क्वेश्चंस को देखेंगे। तो चलिए शुरू करते हैं। द फर्स्ट क्वेश्चन इज देयर आर 5 टाइप्स ऑफ पनिशमेंट करंटली एग्जिस्टिंग अंडर द इंडियन पीनल कोड। 5 टाइप के पनिशमेंट आपके पास इंडियन पीनल कोड में दिए गए हैं। द चीफ एलिमेंट्स नेसेसरी टू कॉन्स्टिट्यूट अ क्राइम आर, सबसे पहला ह्यूमन बीइंग, सेकंड evil intent, and third injury to another human being or society. A has committed no offense when he hurts Z severely while fencing for amusement. अब मान लीजिए A और Z दो लोग अगर फेंसिंग कर रहे थे अपनी अम्यूजमेंट के लिए अपने मन से, तो इस सिचुएशन में अगर A Z को हर्ट कर देता है severely, then A has committed no offense. The right of private defense cannot extend to causing death in case when assault is reflecting intention of causing सिंपल हर्ट। अगर किसी आदमी ने असॉल्ट किया इस इंटेंशन के साथ और उस असॉल्ट की इंटेंशन ऐसी थी कि सिर्फ सिंपल हर्ट कॉज हो, तो राइट टू प्राइवेट डिफेंस कैन नॉट एक्सटेंड टू कॉजिंग डेथ। तब उस सिचुएशन में आप डेथ कॉज नहीं कर सकते अपना राइट टू प्राइवेट डिफेंस एक्सरसाइज करते हुए। फॉर सेक्शन 89 ऑफ आईपीसी द वर्ड बेनिफिट डज नॉट इंक्लूड पेक्यूनियरी बेनिफिट। बेनिफिट डज नॉट इंक्लूड पेक्यूनियरी बेनिफिट्स फॉर द पर्पसेस ऑफ सेक्शन 89। X has committed the offense of criminal force by intentionally pulling up a woman's veil without her consent to annoy her. X अगर किसी women का veil उठाता है without her consent to annoy her, then X has committed the offense of criminal force. The punishment prescribed under Indian Penal Code for a person who maims any minor for begging purposes is imprisonment for life and fine. If any person maims any minor for begging, then the imprisonment is for life and fine. X may be given the punishment of imprisonment up to 3 years or with fine or with both for threatening to publish a defamatory libel concerning Y unless Y gives him money. An offense is punishable under section 82 and section 83 of the Indian Penal Code if it is done by a child of above 7 years of age but below 12 years having attained sufficient maturity and understanding. Two essential conditions of penal liability are guilty mind and wrongful act. The provisions of right of private defense are given between section 96 to 106 of IPC. Consent is not valid under section 90 of IPC if given under the fear of injury by any unsound mind person or a child below 12 years. Causing the death of child in mother's womb is not homicide as provided under explanation 3 to section 299. Punishment for defamation under Indian Penal Code is simple imprisonment for a term which may extend to 2 years or with fine or with both. Assault or criminal force to women with intent to outrage her modesty under IPC is a cognizable and non-bailable offense. Harboring an offender who has escaped from custody or whose apprehension has been ordered if the offense is capital is dealt under section 216 of IPC. The maxim actus non facitrium nisi mensit rea means there can be no crime without a guilty mind. The word injury under section 44 or IPC denotes any harm illegally caused to any person's body, mind or reputation. The famous pronouncement of Delhi High Court regarding constitutional validity of section 377 was reversed by the Supreme Court in Suresh Kaushal versus Naz Foundation. The committee which led to the passing of Criminal Law Amendment Act 2013 was headed by Justice J.S. Verma. Casting couch in Bollywood is an example of sexual harassment. Under section 98 of IPC, Z is not guilty of an offense due to madness and X has the same right of private defense as if Z were sane. अब इसको ऐसे समझ लीजिए कि मान लीजिए Z ने X के ऊपर अटैक किया ठीक है, और Z जो है वो मैडनेस की वजह से नॉट गिल्टी है, बट इस सिचुएशन में भी X के पास सेम राइट ऑफ प्राइवेट डिफेंस है एज इफ Z वाज सेन। अगर Z मैडनेस से नहीं था, ही वाज अ सेन पर्सन, उसके पास सेम राइट होगा। प्रोफेशनल नेग्लिजेंस अगेंस्ट मेडिकल प्रोफेशनल्स इज ऑफन इन्वोक्ड अंडर सेक्शन 304A ऑफ IPC। Voluntarily throwing or attempting to throw acid is an offense punishable under section 326B of Indian Penal Code. Provisions of IPC apply to offences committed by any citizen of India in any place without and beyond India, any person on any ship or aircraft registered in India wherever it may be, and any person in any place without and beyond India committing an offence targeting a computer resource located in India. The offence of sedition was an issue in the case of Queen Empress versus Bal Gangadhar Tilak, Niharendu Dutt Mazumdar versus Emperor, and Kedarnath Singh versus State of Bihar. In तीनों cases में sedition was the main issue in the case. R versus Dudley and Stephen stands for the principle that killing an innocent life to save one's own is not a defense and necessity cannot be pleaded as a defense against murder. किसी की जान लेना to save one's own life, अपनी खुद की जान बचाने के लिए किसी की जान लेना is not a defense or necessity cannot be pleaded as a defense against the murder. If the head of a hatchet flies off and kills a person without want of proper caution from the user, the act is not an offense. अगर एक व्यक्ति hatchet यूज कर रहा था, कुल्हाड़ी यूज कर रहा था और उसका जो आगे का शार्प पोर्शन है वो उड़ के किसी दूसरे पर्सन को किल कर देता है, बट ही एक्सरसाइज प्रॉपर कॉशन, इस सिचुएशन में उसने कोई ऑफेंस कमिट नहीं किया है. A has committed an offense under section 192 of IPC by intending to falsely implicate Z in a criminal conspiracy. If a person tries to implicate another falsely for criminal conspiracy, then such person is guilty under section 192 of IPC. किसी को भी falsely implicate करना criminal conspiracy के लिए, इसके लिए आप section 192 में दोषी पाए जाएंगे. Deliberate and malicious acts intending to outrage religious feelings by insulting a religion or beliefs is an offense under section 295 capital A. Under section 82 of the Indian Penal Code, nothing is an offense which is done by a child under 7 years. The provisions relating to dowry are given under section 304 capital B. Section 315 of the IPC is designed to curb infanticide. The punishments to which offenders are liable under the provision of IPC are death and imprisonment for life, rigorous imprisonment, simple imprisonment, forfeiture of property and fine. अगर आप कोई ऑफेंस करते हो आईपीसी के अंदर तो आपको कौन कौन सी पनिशमेंट्स दी जा सकती हैं? डेथ, लाइफ इम्प्रिजनमेंट, रिगरस इम्प्रिजनमेंट, सिंपल इम्प्रिजनमेंट, forfeiture of property or fine. McNaughton's rules form the basis of law of insanity. A person undergoing life imprisonment if attempts to commit murder and hurt is caused thereby, he may be punished with life imprisonment, death or imprisonment. अगर कोई person who is undergoing a sentence for life imprisonment, किसी व्यक्ति को अगर उम्र कैद की सजा दी गई है और वो उसके अंदर attempt to murder commit करता है और hurt cause हो जाता है उसके रिजल्ट में, तो उसे life imprisonment दी जा सकती है, death दी जा सकती है या फिर imprisonment भी दी जा सकती है. A placing men with firearms at the outlet of a building and telling Z that they will fire at Z if Z attempts to leave the building means A has wrongfully confined Z. अगर A ने बंदूकधारी व्यक्तियों को एक बिल्डिंग के बाहर खड़ा कर दिया और Z को बोला कि अगर तुम बिल्डिंग से बाहर निकले तो जो व्यक्ति हैं वो आपके ऊपर शूट करेंगे, तो इस सिचुएशन में A ने Z को wrongfully confine किया है. A inciting a dog to spring upon Z without Z's consent intending to cause injury, fear or annoyance to Z means A uses criminal force on Z. A causing a cattle to enter in the field belonging to Z intending to cause or knowing that he is likely to cause damage to Z's crop means A has committed mischief. Promotion of class hatred is given under section 153 capital A of IPC. The distinction between section 299 and 300 was made by Justice Melville in Reg versus Govinda. When two or more persons fight in a public place disturbing public peace, they commit affray. The provisions regarding sedition are given under section 124 capital A. Right of private affidavit defense is provided in section 96 to 106 of Indian Penal Code. Provision regarding consent in context of amusement is given under section 87. Instigating any person to do an offense or illegal act or omission attracts section 107 of the IPC. Uttering words with deliberate intention to wound religious sentiments will be dealt with under section 298 of IPC. If the head of a hatchet flies off and kills a man without want of proper caution, आपको याद रखना है want of proper caution means उसने सारे proper cautionary measures लिए हैं. He exercised due diligence. Then the act is excusable and not an offense as contained in section 80 of IPC. In-camera trial is conducted in cases charged under section 376 of IPC. Mahatma Gandhi was jailed and prosecuted by the British regime in 1922 at Ahmedabad under section 124 capital A of IPC for sedition and causing disaffection to the government. If A finds a purse with money and later discovers it belongs to B and appropriates it to his own use, A is guilty of criminal misappropriation. अगर A को एक पर्स मिला जिसके अंदर पैसे थे और बाद में उसको पता चलता है कि ये पर्स B का था, लेकिन उसको देने के बजाय उसने वो पैसे अपने पास ही रख लिए अपने ओन यूज के लिए, तो A is guilty of criminal misappropriation. Offences relating to elections are introduced by IPC by a subsequent amendment. Starting में IPC के अंदर offences related to elections नहीं थे, उनको एक amendment के द्वारा ऐड किया गया. Homicide means killing of a human being by another human being. Adulteration of food or drink is punishable offense under section 272 to 273 of IPC. The maximum punishment for waging war against government of India under IPC is death sentence. Rupan Deol Bajaj versus KPL Gill is a famous case where the Supreme Court decided on outrage to the modesty of women. Outrage to modesty of women का landmark case है Rupan Deol Bajaj versus KPS Gill, former DGP of Assam and Punjab. Outraging the modesty of a woman is punishable under section 354 of IPC. Section 463 deals with crime of forgery. Criminal intimidation is explained in IPC under section 503 to 506. Section 498 capital A of IPC was enacted to meet the cases of dowry deaths. Rule is that penal statutes must be construed strictly. The various words used to denote mens rea under the IPC, for example, voluntarily, dishonestly, fraudulently and reason to believe. IPC के अंदर mens rea denote करने के लिए कुछ words का use किया गया है. For example, voluntarily, dishonestly, fraudulently. The difference between section 299 and 300 was made by Justice Melville in R versus Govinda. Once again, this question comes up. The offense of stalking upon second or subsequent conviction is cognizable and non-bailable. In kidnapping, the consent of minor is wholly immaterial. Kidnapping के case में consent of minor is immaterial. It does not carry any weight. In a cognizable case under IPC, police have the authority to arrest without a warrant and investigate without magistrate's permission. For section 34, common intention must be proved but overt act is not required. Section 34 के अंदर common intention prove करना तो जरूरी है but overt act prove करना जरूरी नहीं है. Grievous hurt under Motor Vehicles Act 1988 means grievous hurt as defined in IPC. The persons taking part in the commission of an offense have been defined in two classes, the principal and the abettor. A issued a warrant to a police officer to arrest P, but the officer arrests Q after due inquiry believing Q to be P. Here P has committed no offense by virtue of section 76 of IPC. A ने वारंट इशू किया P को अरेस्ट करने के लिए, बट जो ऑफिसर अरेस्ट करने गया उसने Q को अरेस्ट कर लिया ये समझते हुए कि Q ही P है, तो यहाँ पे Q ने कोई ऑफेंस कमिट नहीं किया है. Durham doctrine means that an accused is not criminally liable if his unlawful act is the product of mental disease or mental defect. De minimis non curat lex implies trifling acts do not constitute an offense. P and Q agree to commit theft in R's house, but no theft is actually committed. Here P and Q are guilty of criminal conspiracy. P and Q ने agree किया कि वो R के घर में चोरी करेंगे, लेकिन कोई चोरी एक्चुअली में की नहीं, तो यहाँ भी क्योंकि they agreed to commit the theft, they are guilty of criminal conspiracy. Ramu is suffering from a disease of the heart. Rahul, his heir, rushes into the room and shouts in his ear, "Your house has been destroyed destroyed by fire, intending thereby to kill Ramu. Ramu dies of shock. Rahul is liable for the offense of culpable homicide. R commits extortion by obtaining a sum of rupees 50,000 from D by putting D in fear of death. जैसे ही R ने D को fear of death के अंदर डाला और उससे 50,000 रुपए ले लिए, that moment R has committed the offense of extortion. Section 82 of IPC is an illustration for presumption of law. Whoever causes bodily pain, disease or infirmity to any person is said to inflict hurt on the victim. Personation of election is an offense under section 171 capital D. Secretary of a cooperative society is not a public servant. Blackstone defined crime as a violation of public rights and duties due to the whole community. Putting or attempting to put a person in fear of death or grievous hurt in order to commit extortion is dealt under section 387 of IPC. Literally, mens rea means guilty mind, guilty or a wrongful purpose, and criminal intent, a guilty knowledge and willfulness. Mens rea is not an essential ingredient for the offences under the Revenue Acts, public nuisance, criminal cases, which are in summary mode. Actus non facit ream nisi mensit rea means intent and act must both concur to constitute the crime. Cheating and thereby dishonestly inducing delivery of property or making alteration or destruction of the valuable security is dealt under section 420 of IPC. Promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. and doing acts prejudicial to maintenance of harmony is an offence under section 153 capital A. The gist of offence under 120 capital A is meeting of minds. Criminal conspiracy के अंदर meeting of mind is the gist of the offence. The main ingredient of criminal conspiracy is meeting of minds. जैसे ही meeting of minds हो गई, offence under section 120 capital A is made out. A places men with firearms at the outlets of buildings and tells B that they will fire at B. If B attempts to leave the building, the offence committed by A as against B is wrongful confinement. Adulteration of food or drink intended for sale is punishable under section 272. Voluntarily causing grievous hurt to deter public servant from his duty is a cognizable and non-bailable offence. A obtains property from Z by saying your child is in the hands of my gang and will be put to death unless you send us 10,000 rupees. This is an offence of extortion. In IPC, nothing is an offence done by a child under 7 years of age. Right of private defence extends to causing death if the offence is reasonably causes apprehension of death. Section 498 capital A, cruelty includes both mental and physical torture. Preparation for the offence of dacoity is punishable. R versus Govinda distinguish between section 299 and 300. A has committed the offence of rape if he had consensual intercourse with his wife aged about 14 years. So with this, we have done all the previous year questions of Indian Penal Code 1860 that have come under the various examinations conducted by All India Bar Examination. अगर आपको ये वीडियो अच्छा लगा तो वीडियो को लाइक करें, चैनल को सब्सक्राइब करें. अगर पसंद नहीं आया तो मत करिएगा. Thank you for watching. I'll see you next time.